Hello friends, welcome to my channel. I am Rishi Sharma and you are watching Legal Knowledge with Urvashi. In this video, we are going to discuss what is crime, the nature of crime. Further, we'll look into some elements and the stages to commit any crime with the help of the illustration and some case laws also. But before going further, we must look at the Mahatma Gandhi quote. He says, all crime is a kind of disease and should be treated as such. Now, go, now start the video. But before this, please like, share and subscribe my video. Thank you. द टर्म क्राइम जो है वो डराइव किया गया है ग्रीक वर्ड क्रीमो से, जिसका मतलब होता है सोशल ऑर्डर, और ये अप्लाई किया जाता है उन एक्ट्स के ऊपर जो कि किए जाते हैं सोशल ऑर्डर्स के अगेंस्ट और सीरियस कंडेमनेशन नेचर के होते हैं। अगर आसान भाषा में हम बोले तो ये ऐसे एक्ट होते हैं जो कि या फिर ऐसे ओमिशन होते हैं जो कि कमिट किए जाते हैं लॉ के अगेंस्ट, और इसके अंदर ना कि एक इंडिविजुअल सफर करता है बट सोसाइटी एज अ होल सफर करती है। और जो पर्सन ऐसे एक्ट को कमिट करता है सोसाइटी के अंदर उसे हम क्रिमिनल, ऑफेंडर या फिर रॉन्ग डूअर बोलते हैं। अगर हम डेफिनेशन देखें बी ए वॉटले की, उन्होंने कहा कि क्राइम जो है एक ऐसा ऑफेंस होता है जो कि किया जाता है लॉ के अगेंस्ट, और ऐसा जो कि मोरालिटी के अगेंस्ट किया जाओ या फिर सोशल ड्यूटी के अगेंस्ट किया जाता है या सोसाइटी के अगेंस्ट किया जाता है। और ऐसे ऑफेंडर, ऐसे रॉन्ग डूअर को हमेशा जो है लायबल किया जाता है पनिशमेंट से। ऐसे एक्ट को कभी भी कंपेंसेशन से नहीं ट्रीट किया जा सकता, उसको हमेशा पनिश किया जाता है। जो टर्म है क्राइम वो आईपीसी के अंदर या फिर इंडियन लॉज के अंदर डिफाइन नहीं किया गया है कहीं भी, बट एक केस के अंदर करतार सिंह वर्सेस स्टेट ऑफ पंजाब 1994 केस के अंदर सुप्रीम कोर्ट ने ऑब्जर्व किया था कि जो टर्म है क्राइम जो सोसाइटी के अंदर किया जाता है, जो कि सोसाइटी के अगेंस्ट किया जाता है एक पर्टिकुलर टाइम पे, वो जो है वाइडर इम्प्लीकेशन रखता है। इस कॉन्सेप्ट को ये कॉन्सेप्ट जो है वो चेंज होता है अकॉर्डिंग टू द पॉलिटिकल, इकोनॉमिकल और सोशल सेटअप्स के। जब ये ऐसे पॉलिटिकल, इकोनॉमिक और सोशल सेटअप्स जब चेंज होते हैं तो जो डेफिनेशन है या जो मीनिंग है क्राइम का वो भी चेंज हो जाता है। इसलिए जो है ये पावर जो है सेंट्रल और स्टेट लेजिस्लेचर को दी गई है कि वो इससे रिलेटेड लॉ बना सके, कि वो डिफाइन कर सके कि क्राइम क्या है पर्टिकुलर पीरियड ऑफ टाइम पे, और पनिशमेंट दी जा सके उसके लिए। अगर हम एग्जाम्पल लें तो जैसे कि पहले के टाइम पे स्मोकिंग करना वैलिड था किसी भी कैफे या रेस्टोरेंट में, बट आज के टाइम पे वो प्रोहिबिटेड है बाय लॉ। इसलिए चेंज के टाइम के साथ साथ ये चीजें भी, जो डेफिनेशन है क्राइम की, वो भी चेंज होती जाती है। इसलिए हम कह सकते हैं कि जो है क्राइम जो है एक ऐसा एक्ट होता है जो कि कमिट किया जाता है एक किसी इंडिविजुअल के अगेंस्ट, बट वो हार्मफुल होता है सोसाइटी के लिए, और जो कि ये ड्यूटी होती है स्टेट गवर्नमेंट या फिर सेंट्रल गवर्नमेंट की कि ऐसे एक्ट से प्रिवेंट किया जाए, सोसाइटी को प्रिवेंट किया जाए ऐसे से, और ऐसे एक्ट को जो है प्रोहिबिटेड किया जाए उसको, और जो पर्सन ऐसे एक्ट को कमिट करता है उसको जो है पनिश किया जाए बेसिकली। इसलिए ऐसे एक्ट को जो है कंसीडर करते हैं एंटी सोशल एक्ट, और जो कि पनिश किए जाते हैं स्टेट के द्वारा उस क्रिमिनल को जिसने वो एक्ट कमिट किया है फॉर द इंटरेस्ट ऑफ द स्टेट के इंटरेस्ट के लिए। इसलिए जो है स्टेट गवर्नमेंट रिस्पॉन्सिबल होती है। क्योंकि क्राइम जो है कहीं पे भी डिफाइन नहीं किया गया है, बट एक टर्म है ऑफेंस जो कि जरूर डिफाइन किया गया है सेक्शन 40 ऑफ द इंडियन पिनल कोड में। ये प्रोविजन कहता है कि ऐसा एक्ट जो कि कोई पर्सन कमिट करता है और वो पनिशेबल है इस कोड के अंदर, तो हम उसको ट्रीट करेंगे एज एन ऑफेंस। बट हर ऑफेंस जो है, हर एक्ट ऑफेंस नहीं कहलाया जाएगा जब तक जो है इस इंडियन पीनल कोड उसके लिए पनिशमेंट डिस्क्राइब नहीं करती। फॉर एग्जांपल, अगर किसी पर्सन ने किसी का मर्डर कर दिया है, किसी पर्सन का मर्डर कर दिया है, तो उसको, क्योंकि इंडियन पीनल कोड उसके लिए पनिशमेंट देती है, उसको पनिश करती है उसके लिए, तो उससे हम कहेंगे कि हाँ वो उसने ऑफेंस कमिट किया है। बट वहीं पे अगर कोई पर्सन स्ट्रे डॉग का मर्डर कर देता है, उसको मार देता है, तो उसके लिए, क्योंकि इंडियन पीनल कोड उस टाइम पे साइलेंट है, इसलिए उसके लिए कोई पनिशमेंट डिस्क्राइब नहीं की गई है, तो उस एक्ट को जो है हम ऑफेंस की तरह ट्रीट नहीं करेंगे। ऑफेंस भी जो है दो तरीके के हो सकते हैं, एक हो सकता है कमीशन ऑफ एक्ट और एक होता है ओमिशन ऑफ एक्ट। कमीशन ऑफ एक्ट मतलब हो गया क्योंकि सोसाइटी के अंदर हर पर्सन सोसाइटी के अंदर रहता है, तो सोसाइटी जो है एक स्टैंडर्ड ऑफ बिहेवियर जो है वो बनाती है लोगों के लिए कि वो कैसा है जो है बिहेव करना चाहिए एक सोसाइटी के अंदर। पर जब कोई पर्सन उसी स्टैंडर्ड ऑफ बिहेवियर का ब्रीच कर दे, उसको तोड़ दे, उसको ऐसा एक्ट परफॉर्म कर दे जो सोसाइटी के अकॉर्डिंग नहीं है, तो हम उसे कहेंगे उसने जो है ऑफेंस कमिट किया है, उसने जो है क्राइम कमिट किया है। वहीं पे ओमिशन ऑफ एक्ट मतलब हो गया। अब ओमिशन ऑफ एक्ट क्या हो? ओमिशन ऑफ एक्ट बेसिकली हो गया कि कोई पर्सन की किसी पर्सन की कुछ काम करने की ड्यूटी है कि उसको वो पर्टिकुलर काम करना चाहिए, बट अगर वो अपने ही काम को नहीं करता या फिर नेग्लिजेंट हो जाता है अपने काम में, तो उसे हम कहेंगे उसने ओमिशन कमिट किया है। फॉर एग्जाम्पल, अगर कोई सब इंस्पेक्टर जो है अपने सीनियर को देख रहा है कि वो किसी पर्सन को टॉर्चर कर रहा है कस्टडी में या फिर उसको हरास कर रहा है, तो उसकी ड्यूटी है कि जो है उसको रोके, उसको अपने सीनियर को रोके। बट अगर वो ऐसा नहीं करता और वहां से चला जाता है, तो उस टाइम पे उस पर्सन ने जो है इलीगल ओमिशन कमिट किया है। हम उसको कहेंगे कि उसने अपनी ड्यूटी को नजरअंदाज किया है, उसने अपनी ड्यूटी नहीं निभाई है, तो इसलिए हम उसको कहेंगे कि उसने इलीगल ओमिशन किया है। अब एक्ट कमिट हो गया, किसी पर्सन ने एक्ट कमिट कर दिया, ऑफेंस कमिट कर दिया। अब कौन कर सकता है उस केस को? बेसिकली सोसाइटी, क्योंकि ये सोसाइटी के अगेंस्ट किया जाता है, एंटी सोशल ऑफेंस होता है ये, तो इसके अंदर जो है सोसाइटी का कोई भी मेंबर जो है वो केस को इंस्टीट्यूट कर सकता है उस ऑफेंडर के अगेंस्ट। पर कुछ ऐसे एक्सेप्शंस होते हैं, ऐसे कुछ केसेस एक्सेप्शन केसेस हैं जिसके अंदर जो है जो कंसर्न पार्टी होती है, कंसर्न पर्सन होता है या विक्टिम होता है, वो ही जो है केस इंस्टीट्यूट करता है। जैसे कि डाउरी केसेस हो गए, डिफोमेशन हो गए, मैट्रिमोनियल केसेस हो गए। इन केसेस के अंदर क्या होता है कि जो पर्सन, जो कि कंसर्न पर्सन है, जो विक्टिम है, वही केस को इंस्टीट्यूट करता है। क्योंकि अब बर्डन ऑफ प्रूफ किसके है? अब तो केस इंस्टीट्यूट हो गया, अब वो प्रूफ कौन करेगा कि जो है वो पर्सन, जो ऑफेंडर है, वो गिल्टी है या नहीं है। इंडियन पिनल कोड कहती है या फिर क्रिमिनल लॉ कहता है कि जो बर्डन ऑफ प्रूफ है वो हमेशा प्रोसिक्यूशन के ऊपर जाता है कि वो ये प्रूव करे कि वो पर्सन जो है उसने जो है वो गिल्टी है उस ऑफेंस के लिए बियॉन्ड द रिजनेबल डाउट। क्योंकि क्रिमिनल लॉ कहता है कि जो ऑफेंडर है, जो उसके सामने आया है एज एन ऑफेंस, जिसके ऊपर चार्जेस लगाए गए हैं किसी भी ऑफेंस के, वो तब तक इनोसेंट है जब तक कि उसको प्रूव ना कर दिया जाए गिल्टी बियॉन्ड द रिजनेबल डाउट। तो इसलिए ये प्रोसिक्यूशन की पूरी ड्यूटी बन जाती है कि वो जो है वो प्रूव कर दे, उस पर्सन के गिल्ट को प्रूव कर दे। और यहाँ पे जो है डायरेक्ट लिंक होना चाहिए, एक्ट जो कमिट किया है और जो क्राइम हुआ है उनके बीच में डायरेक्ट लिंक होना चाहिए, तभी जो है उसको हम कहेंगे कि हाँ उस पर्सन ने जो ऑफेंस कमिट किया है। क्योंकि हमने लास्ट स्लाइड में हमने देखा था कि लेजिस्लेचर, स्टेट लेजिस्लेचर और सेंट्रल लेजिस्लेचर को ये पावर दी गई है कि वो डिफाइन करे क्राइम क्या है और उसके लिए पनिशमेंट डिस्क्राइब करे। पर इस केस के अंदर देवन्ना नायक वर्सेस सेवा सहकारी बैंक 2008 के केस में सुप्रीम कोर्ट ने बोला कि ये स्टेट तो एप्रोप्रिएट एक्शन लेता है ऑफेंडर के अगेंस्ट कि उसकी क्या ड्यूटी है, उसको क्या उसके लिए एक्शन लेना है, एप्रोप्रिएट एक्शन लेना है। बट साथ ही साथ ये ड्यूटी बन जाती है कोर्ट की भी कि वो जो है क्रिमिनल जस्टिस को एडमिनिस्टर करने के लिए वो ऐसे क्रिमिनल को, ऐसे ऑफेंडर को पनिश करे कि वो आगे ऐसा जो क्राइम है वो आगे कोई और पर्सन सोसाइटी के अंदर नहीं कर सके। Now in this slide we are going to discuss what is the nature of the crime. As in every civilized society, there are the certain standard of behavior which is prescribed by the law, and it is expected by the people that they must observe these standards. But when any person who breach these standards or trying to commit any act which is not according to the society is treated as a crime and is liable for the punishment. But not all the acts are treated as a crime unless they are prohibited by the law and punished by the state. All these actions are taken by the state and it is prohibited by law is only done for the welfare of the society. As the crime is a dynamic nature, it differs from the country to country and the time to time. For example, before the 18th century, the slavery is widely prevalent, but at present time, it is punishable in all the states. For this example, we observe that the crime is changing according to the country to country and also to time. Now, it contains two elements. First is mala inse and secondly mala prohibita. Mala inse is means that the wrong in itself, which is morally wrong, and it is not it observed that the person commit those acts which is beneficial for society, not harmful. But this type of act is harmful for the society, such as murder, rape, kidnapping. So this is all the example of the mala inse. And the mala prohibita means the wrongful act which is prohibited by law. It is not immoral, but it is prohibited by the statute, such as a gambling, pornography, drunk driving cases. Such this type of cases is treated as a mala prohibita. Also, the crime is different from the moral and the social wrongs, because the term crime is means only those acts is treated as a crime which is forbidden or which is breachable and punishable by the state. But in the other wrongs such as the moral and the social wrongs, it is recognized that it is not recognized in the eye of law, and it's not punishable at all by society. So basically, all this act, it means that crime means all those acts which is prohibited by law is treated as a crime, and not other acts which is other acts. As we already discussed what is crime and the nature of the crime, now we have to look into the difference between the crime and tort. And after discussing the differences, we also trying to discuss what is the things which is the common in the both. Firstly, we deal with the difference. As we know that the crime and the tort is different, because the crime deals with the criminal matters, criminal wrong, and the tort deals with a civil wrong. And the crime basically is a violation of the public right which affect the society and tried by the criminal code, whereas the tort is a violation of the individual's right, and it is deals with a civil court, and it's not affect the whole society, but it only affect the party who is concerned in the case. Now the crime is a codified law. Codified law means it's already written and the court have to be followed such laws. The codified laws such as the Indian Penal Code or the Code of Civil Criminal Procedure, and the punishment is also prescribed in these laws, and the court have to be followed these strict rules and procedures which is applied on the criminal for the fixing their liability. On the other hand, in the tort, it is not a codified law, it is a judge made law, and the court basically deals and follow the three concepts: natural principle, justice, and good conscience. The intention, the basically for the commit any crime, there is a two factors which is very important. First, the mens rea, and second, the actus reus. The intention is most important to commit to punish some person for the crime, and the intention must be a bad intention. So, but in the tort, it is not necessary. The mens rea is not necessary factor, an important factor, not a necessary. In the crime, the burden of proof always lie on the state. The state has to be proved that the certain person is commit a crime against the society. Whereas in the tort, the person who claim his right has a duty, or the complainant has a duty to prove that the another person breached the contract or breached their right, their particular individual right. Also, in the criminal cases, there's no that does not permit the settlement of the cases or the compromise between the parties. But whereas in the tort, the party can be settled their dispute in outside the court, and they also the plaintiff can withdraw the suit which is filed by him for the settlement with the another party also. But in the criminal cases, this settlement point is not there, and the party who commit a crime is punished by the court. As a crime is an antisocial act, the person who commit it must make some full-fledged process or the stages to commit it. And it must involve four stages. That is, the first, they have an intention. Secondly, for doing the intentional act, they must do some preparation. Thirdly, they attempt, and when he accomplish or succeed in his attempt, it become a crime. So we have to look into the stages, the four stages, for better understanding with the help of the examples or illustration. The first stage of any to commit any crime is intention. It is a foremost stage and important stage for any crime. The intention means when a person first made his mind to execute his evil plans, it become a intention. At this stage, the offender decide the motive and decide his direction also. Because it is a mental or the psycho stage, the court or the law can't punish a person just for having that intention or the bad intention. Even that it is difficult for the judge to state it that some person have an intention and to constitute any offense, and because it is not done any crime. However, mere intention to commit any offense is not punishable, but there are some provision in Indian Penal Code which stated that even a mere intention to commit any crime, the person can be punished, such as the waging war or assembling for the purpose of committing any dacoity. Now, the second stage is preparation. In at this stage, the person, the intention which is done, the evil intention which is make in the mind of the offender, now come into an action. The preparation means basically to arrange the necessary resources for the execution of that evil act, for the to committing any evil act. Intention and preparation alone are not enough to constitute a crime, because it is very difficult for the prosecution to prove that such preparation done by the person to commit any crime. As the preparation is also stated as an actus reus, because at this time the offender do some to arrange some resources or do some act, basically physical act. For example, if A buy a loaded pistol and keep in his pocket in order to kill a B, but does not do anything, because it is a preparation stage. He done some physical act, but it not to commit any offense. So it is impossible for the prosecution to commit to prove that such person carry a pistol because to kill the B. After the above stages such as intention and preparation, the third step comes is attempt. Attempt means the effort to do something or try to attain any action. And when a person try to commit any intended act, bad act, but he failed to do that act by any reason, it become an attempt. Because it is in a direct movement toward the execution of a crime. After the preparation, we can say that where the preparation end, the attempt begin. Also, there are the three essentials in order to commit a crime or become an attempt is there must be a guilty mind or guilty intention. Secondly, the some act must be done for that with that intention. And third, a person is failed to succeed by any reason. Moreover, because even though the fact is that the execution of offense is impossible, but the person is treated as a criminal, and he must be tried as an tried for that offense, for that charges also. Now the last stage is accomplishment or commission of crime. It is a stage where the offense has completed and the person who committed such crime become a offender or the wrongdoer if he succeed in his attempt. For example, suppose A fire at B with intention to kill him. If B dies by that attempt, A become a guilty of a murder. But if he fails to do so, then he is charged for the attempt of murder, not for the punishment of the murder. Therefore, to commit any crime and for doing these stages of crime, there are one thing common, that is the elements. There are four elements which is responsible or which is necessary, which is involved in any crime. That is the accused person, second, the mens rea, third, actus reus, and fourth, injury. In order to commit a crime, it is important for the somebody to commit it, and the person who commit it become a accused person. And according to the section 11 of IPC, the term person can be defined, which stated that the term person includes a company, association, or the body of person also. Furthermore, if the particular offense is committed by more than one person, in that case, all the people who will face a trial and they will punish together. Now, the second element is an mens rea. According to the law, it states that the person will not commit any crime unless they possess any bad intention in his mind. So the mens rea means a guilty mind, and the mens rea term is derived from the Latin word. There also a famous Latin maxim which is actus non facit reum nisi mensit rea, which basically means that the actor can't be a guilty if it is done or it does not accompany a guilty mind. The third element is actus reus. As the having a guilty mind or evil ideas to commit a crime is not enough. The accused person must have an actor do some actor with an intention or do something in the furtherance. Both mens rea as well as actus reus together are the important to create a crime or to create an offense. And lastly, the last element is injury. When the person commit any crime with the intention and do some act also, the another person become injured, and no crime can be done if no person face some kind of injury. According to section 44 of Indian Penal Code, the term injury defines, which means that any harm caused to the person illegally either in mind, body, reputation or property become a injury. However, there can be some crimes which might not be required for the injury to anybody. For example, driving without a driving license is also a crime, even though they may not harm anybody. So, in short, we can say that the criminal intention plus act become a crime. Now it's time to look into some case laws. The first case is R versus Chessman 1862. In this case, the court trying to differentiate between the preparation and attempt. In the preparation, because preparation is just a physical act in which a person make trying to collect some mean and mode to commit a crime. But in the attempt, it is a direct movement toward the commission of crime after the commencement of it. As the preparation is not punishable, but attempts are. Because the preparation is usually not a harmful act in the society, and it not cause any harm to anybody. But in the stage of the attempt, it might be harmful for someone if it is not controlled, or if he succeed in his act, it become a crime and it harm the society as well as the person. Now the second stage is Arun Kumar versus State of Haryana 2004. In this case, the Supreme Court explained the necessity to punish the offence of attempt. He stated that attempt is made punishable because it must create the alarm or moral guilt of the wrongdoer. It is the same as if he succeed in his act. They and he is liable only for the half punishment as the injury is not greater than the act if it's committed. If the person is succeed, the harm is not as greater as. The next case is Om Prakash versus State of Punjab, 1961. In this case, the accused husband had liable by the court under Section 307, read with Section 511 of IPC, because he intentionally killed his wife by starving her or ill-treated her, which is the main reason for her death. In this case, the court also stated that the beginning of attempt is itself an attempt and made a difference between the intention to commit offense or intention or knowledge which is necessary to make any act as an offense. Because the accused person does the series of act which is a result, which is a main result of his wife death, it's considered as an attempt which lead the victim's death. Now the last case is Narayan Das versus State of West Bengal, 1959. In this case, the accused had undeclared notes sewn in his pant and discovered by custom officers. The court held liable that person because of the actor, which is the actor went beyond the preparation stage and punished under the Sea Customs Acts as he attempted to commit any take currency note out of the country. I hope you all understand what is crime now by the help of the illustration and some case laws. And if you like it, please like, share and subscribe my channel for more related videos. Thanks for watching.